Understanding contract language can be difficult for some clients. Though you can't provide definitive interpretation or specific legal advice, you can offer tips for dealing with the confusing or daunting aspects of contracts. Contracts can be vague and complex, all at the same time. They can also be so inclusive in their language that it might be difficult to figure out who the contract is aimed at. The message can easily get lost in wordiness and jargon. Here are some basic recommendations to help clients better navigate written agreements. 1. Never pressure clients to sign something they don't feel comfortable with or aren't ready to sign. Real estate contracts are about more than land and property. They're about finances, home, security, and legacy. Clients should be sure about what they're doing before agreeing to something. They might have to defend their decision later. Bullying and ultimatums will not be received well by any real estate governing body or court of law. 2. Encourage them to read the contract over at home first. Sometimes being in a familiar room is all a person needs to better absorb the material. Reading in a comfortable environment can aid in processing and retaining the information. It also gives them a chance to discuss the material with a loved one or trusted acquaintance. The third tip is recommending they consult an expert. Be willing to admit your limits. Another person's way of explaining a difficult concept may be easier for the client to understand than yours. Don't take it personal. Just be glad when they're properly informed. Having a second person validate what you already said can reinforce their trust in you. The fourth tip is to provide a list of plain language definitions. Have a list of common definitions available as an insert, a handout, or default attachment to the contract. Many fields, like insurance, banking, and medicine, include a glossary in their contracts. You could also request that a contract lawyer add brief definitions within the language of the contract itself. As someone who uses these words or phrases every day, it may seem unnecessary to you. But clients aren't immersed in the industry. They might not recognize a particular word or phrase when used in the context of a contract. 5. Provide them with examples. Clients are more likely to comprehend the information being presented to them if they're given example situations where the provisions apply. For instance, if a client doesn't understand why a listing agreement has to have an end date, explain what could happen if a listing was left on the MLS indefinitely. In the same example, you might explain why it needs to be updated and the contract renewed if the seller decides to continue to list with a particular broker. Mention that the listing period is like a due date, motivating the listing broker to find a buyer for the property. This may require some creativity, but draw from your experiences. Remember to use general examples without names or particulars. 6. Consider reading a contract aloud to a client as they follow along. Hearing the contract read aloud can significantly improve comprehension. It provides context, inflection, tone, and spacing for cognitive processing. Speaking the words breaks them down into more digestible segments. If a client is unclear about anything in a contract, like how it applies, when it applies, what conditions it applies to, then it's worth taking the time to explain before they sign. Avoidance or dismissal are not acceptable and something licensees should never resort to. Each party's rights and responsibilities are outlined in these agreements, and they should be read thoroughly. That way, all parties are accountable to what was agreed upon. As a final note, read all documents yourself, including standardized forms. Make sure every sentence applies to the current situation. If it doesn't, work with a lawyer to either reprint a customized contract or cross out and amend the standard language as needed. Remember though, all parties must sign and date any changes. If a client comes back with concerns about a clause or stipulation, consider renegotiating the terms. These are legally binding documents. They should be adapted to suit each circumstance. Also remember that not every negotiation has to lead to an agreement. Sometimes it's better to not get involved with a client or transaction that shows signs of volatility, hostility, carelessness, or malice. You don't want to have to pay the consequences later for ignoring your instincts. There's no shame in referring the person to another agent.